on the phone now we have Tor Ekeland, who is a Brooklyn-based lawyer representing both Andrew weev Auernheimer and Matthew Keys. Thank you for joining us, Tor.
A pleasure to be here.
Great. So Tor, let's get started right here with Andrew, who goes by Andrew Auernheimer's case. He goes by weev online, I believe. Yes, weev. And let's
Yeah, that's correct.
Okay, great. Let's start with just what exactly was he alleged of doing, and what were DOJ prosecutors charging him with?
Essentially, he was charged with conspiracy to commit unauthorized access to a protected computer and another count of federal identity theft. And essentially what happened is his co-defendant, Daniel Spitler, who pleaded guilty and, took a plea deal with the government. Daniel Spitler, in I think roughly May of 2010, right when the iPad came out, discovered that if you queried AT&T's iPad email servers with what was essentially a customer ID number. It was a SIM card number, printed right on the SIM card. If you queried AT&T's servers with that number and it actually matched a SIM card number of an actual customer, AT&T's iPad servers would publish a login window, and in that login window would be that customer's address, and then there would be a password prompt where you could enter the password. So Spitler ended up writing a script that basically just counted off numbers, like 1, 2, 3, 4, 5, 6.
Mm-hmm.
And if he hit the servers with a number that wasn't a customer number, nothing happened. They didn't get kicked off. They didn't get asked for a password or anything. But if they hit an actual, customer number, then that customer's email address was published, and they essentially Spitler did compile a list of about roughly 114,000 email addresses. And then Andrew weev took that list and sent it to Gawker after Gawker agreed to, print it in redacted form. He also sent some emails to some members of the media that he found on the list saying, hey, we just discovered this, thing that AT&T's iPad email servers are doing. And roughly about a week later, the FBI kicked in his door, guns drawn in Arkansas, and arrested him. And we went to trial. There was a guilty verdict on November 20th, 2012, and he's now been sentenced to 41 months in prison and $73,000 in restitution.
How? $73,000? What?
Yeah, that's based on the fact that AT&T sent out a direct mailing to inform all its customers, even though it sent emails to them like a week earlier. And so it's like basically they're trying to stick him with the cost of the AT&T's direct mailing to its customers.
So basically, I just want to sort of drive this point home that what you're saying is that what they did basically, weev and his and Daniel Spitler. Basically, what they did was this was all publicly accessible information. There was no breaking of any sort of security system at AT&T or anything of that sort. Correct?
That is absolutely correct. And as a matter of fact, it came out at trial that AT&T had made a conscious business decision to have things set up this way. They knew they could have password protected the email addresses, but they decided for customer convenience that they weren't going to do it. And so essentially, all that's happening here is you've got numbers being entered into a URL, and it's querying a publicly accessible server that AT&T admitted at trial was available to anybody with an internet connection, and bang, now you've got a felony. And I think the implications of that are scary, for a lot of computer users, because I think if this interpretation of the Computer Fraud and Abuse Act is correct, well, then potentially thousands of Americans are committing a computer felony every day.
Did either weev or Daniel Spitler, did either of them contact AT&T beforehand, or on top also additionally did they release the list of emails to the public, or just to the different I believe it was Gawker who wrote the original story that they originally gave the information to?
It's my understanding that they didn't contact AT&T. AT&T found out about it from one of its subscribers that we've emailed. And remember, it was email addresses. There was no emails downloaded, no private information. This is purely about email addresses. And then the list that Andrew supposedly transferred to Gawker was actually never produced at trial, I think all the lists got destroyed, and the only person who got the list was Gawker. And I think the theory behind not going to AT&T with these guys was that essentially that, if you go to these corporations and point these things out, they quite often just bury it, and you don't get a fix right away.
Yes.
Whereas AT&T, as soon as they got all this press, had fixed it really, really fast.
Of course, yeah. After that, yeah. What did AT&T say that? Did they say that there was any sort of a loss on their end? Any sort of? I mean, did AT&T want to pursue this?
AT&T, I don't think is behind this prosecution. There's an email that came out at trial that we put into evidence where, early on the FBI is contacting AT&T, and AT&T's lead, or one of their lead investigators in this matter, just says, I don't see a case here. I don't think a crime was committed. You've got a poorly, designed, system. I don't see it. I think what is behind this prosecution is really the DOJ really wanted to take Andrew out, and they did. I don't think AT&T really was an aggressive force behind this prosecution.
Mm-hmm. I mean, it just seems like they wouldn't want to get any additional press to it. So yeah, I completely could see that. I just want to jump to this past, I believe it was Monday, the 18th. That's when he was sentenced to the 41 months in prison and ordered to pay the $73,000 in restitution. I was reading some of the details that prosecutors were some of the details in terms of which the prosecutors were trying to portray weev. Could you go into some detail about that? I thought that was just unbelievably interesting.
Well, in sentencing, you're allowed to talk about, the character of the defendant and whatnot. So they just pretty much, weev's an infamous internet troll, and they pretty much went to town on that point. They, were pulling out emails where, that made him look bad, even though it's like I couldn't tell what the context of the email was because they just pulled it out of his, Gmail account, and they just basically tried to make him, look like the horrible person who's, out to wreck everyone's lives and make tons of money on the internet, with, that kind of hyperbole that quite often a lot of these people in these computer circles talk with, kind of got pulled out of context a little bit, I think, in the courtroom and just used to, portray him as this horrible threat to the republic that needs to be locked up for everyone's safety, basically.
Mm-hmm. I was just reading through it, and they used he did a I am on Reddit the night before just to talk about his trial, and they used that against him because he talked about his regrets of what he did and how he would have done it if he could go back. Just unbelievable stuff.
Yeah, they monitored him pretty intensely. I hadn't even watched that Reddit feed when they were introducing that in court. But I think he also knew that. In a certain sense, he was a troll to the end there.
Yeah.
And he kept trolling, and he's an interesting individual.
Say the least, yes. One more thing I want to touch upon that, not to spend too much time on this, but I read that they explained the term script kiddie to try to frame him as a hacker. And to me, that's hilarious because knowing a bit about the hacking community, the term script kiddie is usually used as a derogatory term in the hacking community because it's not really hacking. And on top of that, what a script kiddie basically is, I guess, for our listeners, is it's someone who uses a program to basically, just that they didn't even create usually, to try to just figure out information, not even breaking into the system. Like, for example, they use a program to just guess random keywords to try to find out what your password is. It's just complete guesswork. And the fact that he didn't even for example, he didn't even have to guess any passwords or anything like that. The scripting that they used was simply to quickly gain this publicly accessible information. And it's just unbelievable to me that they even brought this term up, script kiddie, as they're trying to call him a hacker when this is it's not a hacker at all.
Yeah, I think there's a big disconnect, a sort of in the understanding there on the DOJ's part about what's going on in the computer world, in the hacker culture. And, they're trying to win a case, so they're trying to portray him as some sort of super sophisticated hacker. And I think the irony, as you're pointing out, is that really it wasn't. any kind of super sophisticated. It wasn't even hacking.
Yes.
I mean, this wasn't
exactly.
a hack, because a hack, I think, really just it implies that you're, trying to bypass a password or you're changing code or something. This wasn't even that. This was just a public query to a publicly accessible server.
So what's the I guess you can say where we go from here with this case? What is the next step for weev?
We're filing our notice of appeal today. We got a great appellate team, Oren Kerr, who's I consider to be like the top computer law scholar in the country. He writes for Law Conspiracy. He literally wrote the computer law case book. He's working on the appeal for free pro bono, and actually I think we will be posting something on the Law Conspiracy later this afternoon, about sort of why he decided to take the case and the issues that he thinks are important. We've also hooked up with the Electronic Frontier Foundation in San Francisco. We got Marsha Hoffman and Henny Fakuri over there, so we've got a really good appellate team, and we're going to appeal this all the way up the ladder if we have to.
Great. FF, yeah, they're a great organization. Before we jump to the Matthew Keys case, I want to quickly just touch upon. I was reading through the I guess you can call it the where was this? The hearing ruling that came out. And the sentencing ruling that came out, I'm sorry. I read that, I was reading through it, and one thing that struck me as very interesting was how you argued how in another case that's currently ongoing, Jeremy Hammond's case. Jeremy Hammond is the individual who is being accused of the Stratfor leaks. And the judge of that case, Judge Loretta Preska, she was asked to remove herself from the case because her husband's email address and those of his clients were part of the Stratfor leak. Their email addresses were part of the leak. She said that she would not be removing herself from the case because the emails were publicly available information and they did not injure her husband. So I mean, and then you argued that if she has this, if the court has this this outlook on these emails, how can they not have the same outlook on these emails in determining weev's offense level?
Yeah, I mean, yeah, and again, email addresses, because it wasn't emails. I mean, I catch myself saying emails too, but I think it's important to note that it's email addresses. It's not even. I do it too. People do it naturally, but there was like no substantive content that they got or anyone's communications. Purely their email address, which I consider to be just like a street address. I mean, these are things that you use to communicate publicly all the time. You're sending them all over the place, and I thought, Preska, had a point there. It's like email addresses aren't a big deal. So yeah, I mean, that's why we saw that in Hammond's case, and we decided to argue that for sentencing.
It's just amazing. To me, it's just amazing how hypocritical that is. I guess let's jump.
Yeah, you got it.
Oh, I'm sorry.
I didn't mean to cut you off.
No, continue.
I mean, I think one of the things is like with this, particularly with the second count in Andrew's case, the identity theft statute, 18 USC 1028A7. It has such a broad definition of what's a means of identification. It basically forbids the possession or transfer of a means of identification in furtherance of another crime. And in Andrew's case, the crime that this was in furtherance was count one, the unauthorized access. But it's sort of like, again, there's no real harm here yet. You've got these felony penalties because of this, and I think the computer statutes here are a little draconian in their penalties when there really isn't any real, harm.
Mm-hmm. Exactly. So let's jump to Matthew Keys. This was also just in the news. Just happened. He received the indictment. I believe it was last Thursday or Friday. Thursday, I believe it was.
Yeah, Thursday. Yeah.
A lot of people know him as the Reuters social media editor. He's goes by Producer Matthew or the Matthew Keys on Twitter. Basically, give us what they're alleging him of doing and what charges he's received.
He's being charged again under the Computer Fraud and Abuse Act, 18 U.S.C. 1030, but a different section of it, and it's not. I think it's a 3-count indictment. What he's being charged for is the transmission of information, essentially to damage a protected computer. And under the CFAA, anything with a microchip is a protected computer. Basically, the definition of protected computer is just, this phone I'm talking on is a protected computer. And they're alleging that what he did essentially is after he was allegedly fired from his job, I believe in like Sacramento for, I think, a Tribune company. They're saying about 2 months later, he was in a IRC room, Internet Feds, which are very notorious IRC room, and that he passed a username and password from the Tribune to somebody in that room, and that they eventually were able to sort of deface this article that was appearing on the LA Times website. And it's like a one-page, very short article on tax cuts where somebody just changed some of the words, like the names from, whatever, Bob Smith to Chippy 1, 2, 3, 4. It's not even clear to me that that's damage under the statute, but now he's been hit. He's facing a maximum, I think, of 25 years in jail and $750,000 in fines. Again, they like to say, the DOJ and everyone likes to say, oh, well, you won't, like with Swartz, they said, oh, you wouldn't have gotten that sentence. But these are still felony counts. You're still in the press as someone who's been indicted as a felon. So, what would he get if he was convicted? I don't know, maybe 1 to 3, but still, and he maintains his innocence. And I believe him. We're going to vigorously litigate that one.
The interesting thing about what he could possibly face is that I was reading online that, for example, let's say somebody did do this and they received the same charges that Matthew is receiving. They would have received less charges, less fines, less prison time if they just walked in and as a way to show their old company off, he just assaulted his boss. He would have received less time.
Yeah, that's a good point. I saw that. There was an Atlantic blog pointed that out, and Hani Fakuri over at EFF pointed it out. Is that if he would have faced a lot less penalties if he'd just gone to the front of the LA Times building and defaced it with spray paint, because it probably would have been a misdemeanor under California law, at worst a felony where you get a couple of years and a few $1,000s in fines. And so there's this weird sort of disconnect. A lot of people have been pointing like the Steubenville rapist only getting 2 years. There's this weird disconnect to having these really hardcore felony penalties in these computer laws that don't jive with our normal, physical old notions of, punishment for serious crimes. Like, these punishments on these computer law statutes are on par with like aggravated assault and rape and, manslaughter and whatnot. And, I think we need to take a step back to see if that's really warranted in the majority of situations. Sure, maybe if you've gone in, you've hacked whatever the Defense Department computer or brought down a financial institution's computer and wreaked havoc on the economy or on national security. Yeah, sure, penalize that. But this kind of stuff, this kind of behavior that people engage in every day to turn it into a felony is I think a little dangerous.
The interesting thing about that is I see people equating it to like if you went out, what he's being charged with doing is equal to if he went out and sprayed graffiti on a wall. But the interesting thing there is, and correct me if I'm wrong, he's not even being charged with doing the actual defacing.
Right. It's a conspiracy charge, and they call conspiracy the prosecutor's friend. So, yeah, he's not being charged with actually having done it. He's being charged with entering into a conspiracy to do it. In a conspiracy, you just have to have an agreement to whose object is illegal and one overt act in furtherance of that. Agreement to commit a criminal act. So that's a sign that maybe their case isn't as strong, but they're still can be tough to beat.
I want to get to the Computer Fraud and Abuse Act specifically, but before we do that, just one last question about the Matthew Keys. What's going on with Matthew Keys? I noticed that a lot of different articles were pointing out that there was a tweet back from March of 2011 from the now notorious anonymous hacker turned FBI informant Sabu, who has been outed as Hector Xavier Monsegur, and he did this outing stem from? Did the charges stem from Sabu outing him online, or was this being looked into before?
I don't know. It's so early in this case. I haven't, had a chance to like get all the discovery. I don't know at this point. That's a good question. I just don't. I don't have a factual basis for answering it right now. Basically.
Okay, great. Thank you. I just thought I would ask, being that I mean, it's interesting to me that all these hacking cases seem to be all these hacking prosecution cases have been prosecuting hackers have been coming from ever since Sabu has been turned this FBI informant after he was caught. I just find it to be incredible.
Oh yeah, I find it really interesting too, and believe me, it's something we'll be, looking into.
So let's jump quickly to the CFAA specifically. Can you quickly and briefly just I guess give us an overview of what it is and how it's being used against? I mean, it was most famously used in the late Aaron Swartz's case. He was facing, what was it? I think 35 years in prison under the CFAA for basically going into MIT closet, connecting his laptop to their network, and accessing like a mass amount of publicly accessible academic journals, and just amazing. 35 years for that. So what is this act, and what does it say, and how's it being used against these people?
Well, the Computer Fraud and Abuse Act originated in roughly, I think it was 1984, and before the internet, before HTTP, iPhones, iPads, everything, and essentially it was designed to protect, federally protected computers, and I think major economic institutions, and then slowly, over time, gets amended, and it does a number of things. The main thing section that you're seeing in most of these prosecutions, like Swartz and Auernheimer, is it forbids unauthorized access to a protected computer. Like I said before, a protected computer is just anything with a microchip. The problem with it is that it doesn't define anywhere what unauthorized access means. And so you've got the courts all over the country. You have different definitions of it. Some people are like, oh, just violating the terms of service of a website means unauthorized access, which I think is an extremely dangerous interpretation because everyone's really committing a felony every day. But it's become like this tool of the DOJ because it's so malleable and I think so broad and vague for prosecuting anybody who essentially has done anything that they think is remotely wrong with the computer. And I think it needs to be amended. And there's EFF is working on that. A number of people are trying to get this statute under control.
It's funny how I've been reading some of what EFF has put out on it, and especially I mean, today is the 7-year anniversary of Twitter being launched, and I found it interesting how they named off all these big names in tech and just innovation entrepreneurs who could have been and would have been probably tried under this act if they were doing this today. I mean, Steve Jobs, Bill Gates, Mark Zuckerberg, Twitter founder Jack Dorsey just recently was talking about how he got his start hacking. And again, hacking is not necessarily a bad term. You could hack for good, hack for bad. You could just hack any product. You could hack a product you own, like how you could hack an Xbox 360 you purchased to do something that maybe it was not originally meant to do in the operating system, but you have it, playing files from your computer or something. It's just amazing to me how they're trying to just turn the term hacking into this amazingly negative term. I mean, the press and people in general always had this, I guess, negative connotation of hacking. But what we're seeing in just recent years is just this complete, I can't even explain what they're doing with this. They're just grabbing anybody who has any knowledge or savvy in computers and technology, and they're trying to just try them under this act, it seems like to me.
I think, I've said it before, I think hackers are the new communists for the DOJ. I think there's a lot of irrationality and fear out there because people don't understand, what's going on in the computer world. There's a big disconnect. All sorts I get contacted by computer security researchers and even people like they're doing data mining for the financial services industry freaking out about these prosecutions because they just consider it to be just normal, computer behavior. And so, there's this big disconnect from the people who don't understand anything about the computer world, who are actually writing these laws, and then the people who actually work, in the computer world, who just, think these prosecutions are insane.
We were joking in the office the other day about how we remember there was a time when they would find a hacker like this, not like this at all, an actual hacker who actually found a flaw in a security system and broke in and was able to manage access this back end management system, and how they would find these people and they would use their savviness and their intelligence to, they would cut a deal and use them. Like what happened to something like that where they would cut a reasonable deal with these people, and what did they just fill up all their hacker job slots? I mean, I don't quite understand why they're
Yeah,
they're
yeah.
going full force on these people now when they used to, at the very least, offer them some sort of reasonable deal.
Yeah, and I think that's what the Chinese are doing with their hackers. I mean, they're
That's a great
all
point.
their hackers
That's a
have
great point.
really, really good government jobs, I think, over there. And I think, what you see with a lot of these people, like you mentioned, Steve Jobs, Bill Gates, and all our, Swartz, all the great computer innovators. They do this stuff because it's part of their process where they're learning, about computers and systems and whatnot. And I think it's very fundamental to their ability to innovate. And I think if these prosecutions had been around, in the 70s, you wouldn't have Apple Computer, you wouldn't have Microsoft, and you would have had a chunk of our GDP wouldn't exist. So I think there's an economic harm in what's going on with these prosecutions that I think is bad for the country.
The weird thing about all this happening just now to me too is not so much weird, but just hypocritical again, and just completely unbelievable that just the end of last year, the Supreme Court declined to review a lower court ruling in a case that challenged a Bush era law, which is the FISA Amendments Act, which basically retroactively gave telecommunications firms like Verizon and AT&T, that they gave them legal immunity for performing warrantless wiretapping. I mean, how can you say that AT&T has the ability to just not respect their customers' privacy, but an individual can't publicly access information that AT&T is using? I mean, that AT&T has made available because they don't respect their customers' privacy.
No, I know. I think that's a good question, and I think that it's disturbing that they got that grant of immunity for warrantless wiretapping on U.S. citizens. That's extremely disturbing.
I just really want to try to drive home the point here to listeners that I mean, regardless of what you think about someone like a weev or a Matthew Keys or their their internet histories or whatever, there's two things going on here I think that's important to drive home. Number one is that none of these cases are hacking cases. They're just not hackers, and that's what
Yep.
they're basically being tried for to the full extent of the law. And then number two is that these laws are so draconian that regardless of whether you think any hacker is guilty or not guilty in their case, the sentences they're being dealt do not fit the crimes that they're being accused of.
Mm-hmm.
And I just want to, I feel like those are the two important points here to drive home to people, because I see, a lot of people talking about these two cases because they're the most recent, but just hackers in general where, they deserve to be punished or whatnot. And I think it's important to separate people who actually do hacking from people who just discover this, just like you or me could have discovered, like what weev and his what his partner, I'm sorry, I forgot his name, did basically.
Daniel Spitler.
Yeah, any one of us could have come across that. It was just a public URL. And with Matthew Keys' case, I mean, that's not a hacking case. And in terms of him, I'm seeing just so much, and weev too, just so much, negativity to their character. And I mean, you could think what you want, but I think it's important to drive home that one, these aren't hacking cases, but that's what they're being perceived as. And number two, that whatever you think their punishment should be, what they're being charged with just does not fit the crimes. And I just want to thank you.
Yeah, I agree. And the one thing I would add to that is that these laws are so broad and vague that they potentially encompass, computer behavior by criminalized computer behavior by thousands of Americans engage in every day. And the government historically always goes after the unpopular defendants first, But people should be concerned about these prosecutions because the law is so broad and so vague it invites arbitrary prosecution by the government.
I mean, it makes so much. I mean, especially in the weev case to me, because I mean, if you or I came across this information they came across, I mean, maybe we wouldn't have the savvy to pull the information like they did, but people should know about this. That AT&T and other companies that you're paying money to and your customers and you are customers of, just care so little about your personal information and your privacy that they're willing to save a buck to just leave this information out there.
Yeah. Yeah.
Tor
You know,
Ekeland, I just want to. I'm sorry. Continue. If you have something else to say.
Oh no, that's it. That's.
Tor, I just want to. Tor Ekeland, I want to thank you so much for joining us. We'll be following the cases of where weev's case goes from here, and Matthew Keys' case, which is just beginning. Thank you so much for joining us today.
Well, thank you for having me. I really enjoyed it.